I'm ready. Here it is.
Yeah, who are you ready on?
I have Nathan Sampson.
All right, Mr. Sampson. All right, it's cause number CR 2135, State versus Nathan Sampson. I believe this is a motion to revoke.
It is, Judge. We received an offer from the state here recently. I think that we'll probably end up resolving Mr. Sampson's case by plea, but we'd ask for now that it be set on that May 10th docket. Hopefully.
All right, court will set Mr. Sampson for hearing on his motion to revoke. It won't be the contested hearing, but it'll just be basically an announcement on his motion to revoke on May 10th. That'll be at 1:30.
Yes, sir. That's all I have. Can I be excused?
Yes, sir. Thank you, Mr. Schmidt. Sorry for the delay.
Mr. Adams?
It was a write-in on my docket. Very nice. Back page, just for Who are you ready on, Mr. Adams?
Your Honor, I'm ready to go on each one of mine if you just want to call them in whatever order.
Okay. Stephen Foster, CR 21-214. Mr. Foster set for docket call.
Yes, Your Honor. State has made a new offer to me earlier today on Mr. Foster's case. I've relayed that offer to Mr. Foster. He has not yet indicated to me whether or not that's going to be something that he will accept. I'd ask the court to reschedule for another docket call to give Mr. Foster and I some time to discuss the pros and cons of the state's new offer.
Any objection from the state?
No, Your Honor.
All right, court will reset Mr. Foster then for the final docket call on May 10th. It'll be at 1:30. Adam Joslin, CR 21-329.
Okay.
All
right, Mr. Joslin set for pretrial.
Yes, Your Honor. We don't have any pretrial issues to take up at this time. However, I would ask the court for an additional pretrial hearing. I am still looking for an expert witness to assist me in preparing the defense of Mr. Joslin's case. In this case, defense in his case. I have visited with one potential expert witness. That person is in Ohio. I'd like to find somebody a little closer to home.
Any objection from the state?
No, Judge.
All right, court will reset Mr. Joslin. You think May 10th will be sufficient, Mr. Adams?
If you make it May the 10th, it'll be sufficient, Your Honor.
All right, we'll make it May the 10th, 1:30.
Yes, sir.
Roger McCaslin. Mr. McCaslin set for pretrial.
Yes, Your Honor. Your Honor, I don't have any pretrial issues to take up at this time. I would advise the court that I'm still reviewing the discovery materials in the case. And I would ask for one more pretrial setting for him so that I could finish doing that and determine whether and what, if anything, I need to file in the way of pretrial issues.
Any
No
objection?
No objection from the state.
Thank you, Mr. Woodwhite. Court will reset Mr. McCaslin for an additional pretrial on May 10th. Brent Lee Smith, CR 21392. Mr. Smith is set for docket call.
Yes, Your Honor. I have no issues to bring up with the court right now. We've have a plea offer from the district attorney's office. I'm not sure that it will get resolved that way. If the court wants to carry us over for another docket call, to give me some time, some additional time to negotiate with the state, that might be worthwhile. There's a good possibility that this will be headed for a jury trial.
State.
Judge, we're unopposed to one more setting if Mr. Adams thinks that there's something that might be helpful for us to know in negotiating plea negotiation.
Do you think that exists, Mr. Adams? Do you think, is it going to be just you asking for less, or is it going to be you giving something to the state to make them consider giving
Well,
a reduced offer?
Your Honor, I'm pretty charming. But aside from that, I wouldn't represent to the court that I have any information that the DA's office is unaware of.
Okay. Let's just go ahead and set this on the jury selection docket, and if the state and defense reach an agreement, then you'll let me know, and the court will entertain it.
Yes, sir.
So what we'll do is we'll set this for jury selection beginning on May 2nd. Obviously, Mr. Smith won't reach jury selection that day, and this, looking at the type of charge that says it's likely to, the court may consider setting this for a special setting, but we're not going to do that today. I may do that in the future, consult both state and defense.
Yes, sir. Carl.
Thank you, Your Honor.
You're welcome. Is that all you have, Mr. Adams?
Yes, Your Honor, it is. May I be excused?
Yes, sir. Thank you. Appreciate you being here.
Bye, Caesar.
Hearing anybody else?
Your Honor, we should have a couple of more bodies up here momentarily, but they're just not right here right now.
Hey, let me ask you about Brett Turnage.
I was just going to ask the staff about him. When the officer returns with the other bodies, I was going to check on his status.
Yeah, well, I see that he's still number 188 on the psychiatric list, and he's scheduled to see a psychiatrist on the 18th. I think what I would like to do is his attorney, Mr. Wood's not here today, but we have another attorney, his partner, Mr. Rollins. I think I'm just going to bring Mr. Rollins in, and let's just pass this case until after he sees the psychiatrist. And we'll do another update maybe here in a couple of weeks. That way Mr. Wood can be back, and that way we don't have to bring him out.
Okay, thank you for that. And we do have two people that just got here with Mr. Stevens, but I think he's visiting with them for a moment. Would you like to take care of that matter, then come back to us?
Yes, ma'am, I'll do that.
Okay, thank you, sir.
Good afternoon, Mr. Rollins.
Good afternoon, Judge. How are you?
Doing fine. I appreciate you standing in for Mr. Wood.
Yes, sir.
Mr. Turnage, obviously in our custody. I had some notes. This is cause number CR 2198199. Mr. Turnage is still number 188 on the admission list. I also have a note that he's scheduled to see the psychiatrist on April 18th. So I think what I want to do is I'm just going to reset this. I'm not going to bring Mr. Turnage up today. I want to reset it, allow Mr. Wood to be here, and I want to get on the other side of that psychiatrist appointment with Mr. Turnage. So if you don't have any objection to that, and if you have anything else to add to the case, let me know.
No, sir, I have no objection to that.
Okay. All right. Let me look at my calendar here. Tell you what, let's set him on April 26th. That's 2 weeks. Do you know if Mr. Wood be available that day? April 26th.
I can take a look real quick, Judge. That looks like a good date for us.
Okay, we'll put Mr. Turnage down for 1:30 on April 26th, just a status. We'll see if we have any additional information from that psychiatrist on that day.
Yes, sir.
All right, thank you, Mr. Rawls. I appreciate you, sir.
Okay, thank you, Judge.
Your Honor, Mr. Stevens is ready now.
All right, good afternoon, Mr. Stevens.
Good afternoon, Judge. I have two cases. You can call them whichever order you prefer, Your Honor.
We'll call Donald Patterson, CR 2351. Mr. Patterson, set for docket call.
Yes, sir. I have received an offer from the state. Matter of fact, we've negotiated a couple of different offers back and forth. At this time, my clients rejected all the offers, so it might as well go to the trial docket.
Okay. And can you tell me what the offers were that Mr. Patterson rejected so we can have that on the record?
Yes, sir. I think, if I'm not mistaken, Judge, the first offer was 15 years. And if I'm not mistaken, the latest offer was 8 years. I think that is correct, Your Honor.
All right. And so does your client understand, Mr. Stevens, that once he elects to have a trial, the court will schedule him for a trial, and as we move near to selecting that trial, Mr. Patterson is not going to be able to change his mind and later say that he would like to take the 8 years if that was offered?
Yes, sir. He is aware of that. We've had that conversation before, plus now he also is aware of it.
Okay. All right. Court will set Mr. Patterson for jury selection on May 2nd. Obviously, you will not go to trial on May 2nd, Mr. Patterson, but what's going to happen is I'm going to place you on that docket, and you'll continue to be on that docket until your case is reached for trial. You'll sit on that docket, and you'll move as cases are heard or pled or resolved or tried, then you'll move up that list. But this is just where I'm going to start you on May 2nd, and you'll get a notice each time we have a jury selection that you'll be moving up, okay?
Fantastic. Thank you for everything
All
you've
right.
done.
You're welcome.
Thank you, Your Honor.
Thank you, Mr. Stevens.
Yes, sir.
Joseph Aguado, CR 21-317. Mr. Aguado, how are you doing today?
All right.
All right. All right. We are having a hearing today on Mr. Aguado for just a status. Mr. Aguado, I believe, has been found incompetent to stand trial. And I see that there's a notation on my docket that he was moved from the maximum security list to the forensic list. And I see that he's also scheduled to be meeting with a psychiatrist on April 18th next week. So you have any other additional information for the court, Mr. Stevens? Or
I do not, Your Honor. I have visited with my client again, and he seems pretty much kind of like what you see him now in front of the court, Your Honor. He's just doesn't know what's going on.
Yeah. Well, and I hope that on the 18th, when he sees a psychiatrist, if there's a need for mental health meds, we can go ahead and get those going now while we're waiting for his admission into the forensic unit. So
Yes, sir.
let's go ahead and schedule this for another status. Are you available on May 24th at all, Mr. Stevens? That's a Tuesday.
No, sir. I'll be coming back from vacation that day.
What about June 14th or 16th? Or June 2nd?
14, 16 are good. The second is good, whichever date you want, Your Honor.
Let's do June 14th. And that'll give us some time for psychiatrists to do their work.
All right. Thank you, Your Honor. I'll be excused.
Yes, thank you, Mr. Stevens. Thank you, Mr. Aguado.
Let's go, Judge.
Good afternoon, sir. Is this Mr. Nino?
Yes, sir. Yes, sir. Very loud.
All right, this is cause number CR 21301, State versus Pedro Oliveira Nino. And today is a plea to the charge of intoxication manslaughter with a vehicle. Is that correct, Mr. Bolton?
Yes, sir.
Okay. All right, Mr. Nino, if you will, sir, raise your right hand. I'm going to place you under oath. Mr. Nino, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth? So help you God.
Yes, sir.
All right, you may put your hand down. Mr. Nino, are you a United States citizen?
No, sir.
You're not. And prior to you accepting any type of criminal responsibility for this action in a plea agreement, have you discussed your immigration status and your legal status in this country with either Mr. Bolton or some other attorney regarding what effects this plea may have? And Mr. Bolton, if you want to talk to that.
Yeah, we went through it. Mr. McCaslin has gone through this with him previously, and I have as well again today, that a plea of guilty on this charge will almost certainly result in removal proceedings by the Department of Homeland Security.
Okay. And so you understand that, Mr. Nino?
Yes, sir.
Okay. All right. And Mr. Nino, have you, do you read, write, and speak English?
I speak a little bit English and read a little bit.
Okay. And when you read through the paperwork today, did you have the assistance of your attorney, Mr. Bolton?
Yes, sir.
And do you feel like you understand or have had an opportunity to understand everything that you have read and reviewed?
Yes, sir.
Do you have any questions about any of the paperwork that you've read and signed?
No, sir. I'm pretty good.
All right. And are you pleased with Mr. Bolton's representation of you? And have you ever been diagnosed with any type of mental condition?
No.
Okay. And Mr. Bolton, do you believe Mr. Nino to be competent today?
Yes, sir.
All right. You've explained to him his legal rights, and you believe he understands them?
I do, Judge. They've been reduced to writing.
Okay. All right, Mr. Nino, I see here that you have been charged with the second-degree felony offense of intoxication, manslaughter with a vehicle. A second-degree felony in the state of Texas carries a range of punishment of not less than 2 years or more than 20 years confinement in the Texas Department of Criminal Justice. It also carries an optional fine not to exceed $10,000. Do you understand that range of punishment?
Speak up.
Okay, you're going to have to say yes or no, so my court reporter who's here with me can write it down.
Yes, sir.
Okay, so any sentence handed down by this court or jury would have to fit within that range of 2 to 20, and a fine not to exceed $10,000. I see that the plea agreement in this case is that you're pleading guilty to this charge, and the state of Texas is recommending that your punishment be set at 4 years confinement in the Texas Department of Criminal Justice with a $2,000 fine plus court costs, reimbursement fees, and you would receive 317 days credit towards your sentence for the time that you've spent in jail on this case. Is that your understanding of the plea agreement?
Yes, sir.
Mr. Nino, understanding the plea agreement, the range of punishment, and all the paperwork that you've read and signed today, do you still wish to go forward? Okay. All right. At this time, Mr. Nino, how do you plead to intoxication, manslaughter with a vehicle?
Guilty.
And are you pleading guilty to that crime because you are guilty of committing that crime?
Yes, sir.
Has anyone threatened, forced, or pressured you to plead guilty to this offense?
No, sir.
All right. The court accepts the defendant's plea of guilt. Mr. Bolden, any objection to the state's evidence as offered?
No objections.
All right, state's evidence is admitted and the court takes judicial notice of the defendant's judicial confession. Anything further from the state with regards to the plea and or victim notification, Ms. Heisel?
Yes, Your Honor. The state is in compliance with victim notification, and I believe that Ms. Cheney forwarded a victim impact statement to the court before this plea. We would ask that you review that at this time.
All right, thank you, Ms. Heisel. Anything further from the defense?
Not at this time, Judge. Well, I will note that there's not a special finding as far as a deadly weapon is concerned in the indictment. And there's not one reflected on the judgment. I don't know if that was omitted, but
Was that negotiated in your plea?
I don't know if we had that discussion with the state. It's not included anywhere in the indictment or the judgment. So I'm advising the defendant that there's not a deadly weapon finding in this case, absent to some sort of documentation from the court on the paperwork to the contrary.
Yeah, I don't see one alleged in the indictment, and you're right, it's not in the judgment, so the court wouldn't be making one.
Very well, thank you, Judge.
Thank you for pointing that out, Mr. Bolden. All right, the court has reviewed the evidence. The court's also reviewed the victim impact statement as provided by the prosecution. The court has signed the victim impact statement. The court will follow the plea agreement as recommended by the state of Texas. Court hereby convicts Mr. Pedro Oliveira Nino of intoxication and manslaughter with a vehicle. Second-degree felony. The court assesses his punishment at 4 years confinement in the Texas Department of Criminal Justice. Orders him to pay a $2,000 fine, $290 court cost, $20 reimbursement fees, and awards him 317 days credit towards his sentence for the time that he has spent in jail on this cause. Mr. Nino, you hereby remanded to the custody of the Van Zandt County Sheriff so he can carry out the terms and conditions of the sentence. I'm going to have you step over with Deputy McCleese to your right to be fingerprinted. Thank you, Mr. Bolden.
Have a good day.
Everyone else ready? Deputy
Your
Commissioner?
Honor, we don't. Mr. Ashmore is here, but he's working with his clients, and Mr. Simmons has got some paperwork he's got to do. So I'll just let you know, I guess, when we're ready. Is that okay?
Yes, ma'am, please.
Thank you.
Mr. Simmons, are you ready? If you're, yeah.
Your Honor, I am waiting on paperwork.
Okay, I just wanted to make sure. I saw you sitting there. I didn't know.
I appreciate it very much, Your Honor.
Okay, thanks.
Yeah,
You are not muted anymore, Casey. Your Honor, if you're available.
Is this the only room in the jail that the AC doesn't work?
I don't know.
It's usually freezing in here. Just the judge's idea to speed us along. Oh,
I don't know. Didn't work with the other crew the last 3 weeks over the courthouse.
Yeah. Shut the air
I
off.
think you would come up with a better plan.
Close the windows and lock them in.
All right, Mr. Ashmore, you ready?
Judge, I'm ready on Miss Lopian.
All right, this is cause number CR 21224, State versus Theresa Gene Lopez, set for docket call. Go ahead.
Judge, we have a plea offer that we received from the state of Texas yesterday, and I've talked to my client, but we actually have two. The offer that my client and I would like to accept is a 6 TDC with $1,000 fine offer. And we'd like to request the court reset us to plea. May 10th seems to be the next available. Is there room on that docket, Your Honor?
I can get you sooner if you want. We could do April 26th. That's 2 weeks from today, or I can put you on the May 10th.
Ms. Lopian is shaking her head in acknowledgement of the 26th. I'm checking my calendar. Just 1 second, Your Honor. Judge, I think I'm out that day.
Or you can come back and do it Thursday if you're available this week. If it's just you need time to do the paperwork.
I can come back Thursday. She'll be in Henderson on Thursday, though. Or can she be brought back?
She can be brought back if we need her back.
I guess then my next question would be to Mr. Woodwike and Ms. Heisel. Can Stephanie get that done without murdering me by? I know y'all want to murder grade again, but I don't want to incur any more wrath from Miss Abney.
We can do it. We can do it by Thursday.
Okay, you want to do Thursday? Then Judge, we request to be reset this Thursday, and we'll get that paperwork from Miss Abney and be squared away and ready to go.
Okay, we'll reset her for plea then on Thursday of this week. And that'll be before Judge Brabble. And he'll actually, I think, is planning on coming out to the jail to conduct the pleas.
Thank you, Judge. May we be excused?
Yes, thank you.
Okay.
Thank you, Your Honor.
So these are the options. Okay. All right, Mr. Ashmore, you ready?
I am, Judge.
All right, who do you want to go on first?
Is that Mr. England in the courtroom?
Yes.
If,
No, let's do your inmates and get those done so you can get out of there so I can get your other inmates. We're going to shut that place down.
right on, Judge. I know we have a Tad Michael Russell zooming in from Henderson at 1500 hours, which I believe is right now.
Yeah, he's not logged in. So we can go with your other ones. We go Justin Keenan, Jerry Elmore, Alex Manus. I mean, any of those.
Alex Manus, I'm ready on that one, Your Honor.
All right, Mr. Manus.
Judge, just to be clear, he is still in his cell. I have walked back there again and checked on him. He's verbalizing better than previously, but he's had some recent issues with temperament and hygiene that it's my request and belief that he probably needs to stay there. Although he was articulating better and looked better than he has, certainly in my last visit.
Okay. So
But we're still waiting on the bed. I'm sorry, Judge, you go ahead.
So you're asking to waive his appearance, correct?
I am, yes, Judge.
That's granted. This is cause number CR 2182. I see that Mr. Manus is number 96 on the Terrell State Hospital list. I also see that he met with Dr. Corman today with the Andrews Center. Dr. Corman has diagnosed him with schizophrenia and believes that he will need some mental health medications. And he believes that if he's not willing to take those, that the next step would be to get those to administer those without his consent. So,
Understood.
trying to determine if we need to set a hearing for that. Do you know if Mr. Manus is in a position where he can agree to take those or not?
It really just depends on the moment. I don't know if he would voluntarily take them. Today he might. It sounds like from my interview with the staff here that perhaps a week ago he would not.
All right, so let's do this. Let's set. We'll reset this case and we'll set it for also a hearing on the application. Dr. Corman has filed an application to administer psychoactive medications, and we'll set that on. Set that on May 10th.
Yes.
That'll be it. We'll set that at 1:30 as well.
Yes, Judge.
So that'll be a status and it'll be the application to administer psycho meds. All right, who else you ready on?
Damian Wilson, Your Honor.
Mr. Wilson, come on up, sir.
I'm sorry, say that again, Mr.
Damian Wilson, Your Honor.
All right, Damian Wilson, CR 2234-373. He is set for pretrial. Go ahead.
Judge, I don't have any pretrial motions on file, and I'm not anticipating filing any at the moment. I am going to ask the court for an additional pretrial hearing. I'm going to ask the state to not oppose that. There are some things that Mr. Wilson and I have discussed that I believe I'm going to look at. I need to look into. I need to present those to the state because it might change the position of our plea discussions, and that being related to his release from Van Zandt custody and transfer to Dallas back in 2019 before all this started and before he was charged with these offenses. Right now, the current offer is 15 TDC on either charge. And again, we're asking the court's permission for at least one additional pretrial before we're set for docket call to see if I can square this away with the state of Texas and before we finalize our plea discussions.
Any objections from the state?
I don't believe so, Your Honor.
All right, court will reset. Mr. Wilson. How about I just set it for docket call? Is that fine? Does it need to be reset for pretrial or is docket?
No, that's probably fine, Your Honor. I just don't want to waive anything.
Well, let's set it for docket call, and then if there's a need to file a pretrial motion, then you can seek leave, and the court will cite this hearing today. Grant that for you, okay?
Okay, thank you, Judge.
We'll set this for docket call on May 10th. 1:30. Are you ready on Jerry Elmore?
I am, Judge.
Mr. Elmore? All right, this is cause number CR-21-355, State versus Jerry Ray Elmore for docket call.
Judge, we're thankful for the extra opportunity to be back on Mr. Elmore's case. I visited with his wife. I visited with him, but only briefly. The state has extended the offer of 8 TDC. They said, in fact, that they would agree to my request of 6 TDC. It's my understanding at this time, after confirming with both Mr. Elmore and after talking to his wife, that he is not agreeing to either of those at this time. I'm going to ask the court for either an additional docket call. It'd be my preference to have a little more time to visit with Mr. Elmore about the potential exposure he may face with a jury before we set this case on a rolling jury docket.
And I haven't reviewed the indictment in this case. Is this case susceptible to a enhancement? Is that why the offers are what they are? Or is
Yes, sir. Yes, Your Honor. I believe it's a second degree. It's punishable as a second degree.
Okay. Any objection to Mr. Ashmore's request for an additional docket call?
No, Your Honor.
All right, court will grant Mr. Elmore an additional docket call till May 10th so that Mr. Ashmore can complete discussing his legal rights with him.
Thank you, Judge.
You ready on Justin Cannon?
Mr. Cannon's ready, Your Honor.
All right, this is cause number CR-21-282, State versus Justin Lee Cannon. Had the impression that Mr. Cannon was going to resolve his case today in plea, but now it's my understanding that he's not wanting to plea and instead wanting to ask the court to terminate court-appointed counsel. Is that correct, Mr. Ashmore?
Oh, I didn't know about that, Your Honor. I did know that we had a video conference phone call shortly after his arrest for violating the terms of his pretrial release, and that in light of the risks, he urged me at that time to take the state's offer of 20 TDC and dismiss all the rest of his business that may be pending before the court, which I understand is not going to be helpful at a jury trial. I wasn't aware of a request to terminate, but I assume that's before you. And at this time, Mr. Cannon has revoked my authority to enter that plea agreement. So I apologize to the court and to the state of Texas for taking the effort to get that done for Mr. Cannon. And as far as the other matter, I wasn't aware of it until you mentioned it, Judge. So I'm ready on that one as well.
All right, court's going to reset docket call for Mr. Cannon, and I'm going to give you an opportunity, Mr. Ashmore, to review the signed defendant's concerns with court-appointed counsel form that he filled out that makes allegations about you. So I'm going to give you an opportunity to review those and be able to respond. We're going to reset this case for an additional docket call on May 10th at 1:30, and I'll take up your concerns at that time, Mr. Cannon. but I'm going to give Mr. Ashmore a chance to prepare for those. All right, so we'll see you back on May 10th. Ready on Casey Spriggs?
Mr. Spriggs,
So CR 21-371, State versus Casey Lynn Spriggs. We're set for pretrial, and also have a note that Mr. Spriggs also wants to terminate you as his court-appointed counsel.
yeah, I have seen that note, Your Honor, so I'm going to address the pretrial motion first. We have a pretrial motion on file requesting certain, well, as broad as we're allowed to request under the Michael Morton Act. I have conferred with the state about those requests. My understanding is Mr. Woodwike has, or is in the process of subpoenaing some of those items from Swifts in Dallas, Texas. I don't know the status of those at this point, but we've had an exchange, a communication about that within the last 7 days. And I've also made a request to see the murder weapon if it's here. And again, my understanding is that the state is working to accommodate these requests. So as far as the complaint in that form,
Well, let's do this. Let me allow the state to respond. State, do you want to update or confirm any of the things that you are trying to discover for Mr. Ashmore on his request?
Yes, Judge, we received Mr. Ashmore's motion for discovery. We have contacted the Southwest Medical Swifts to receive the full autopsy report. They're in the process of getting that to us. My investigator is doing that. We're also looking into the presence of the murder weapon itself, which may or may not be in the custody of the Van Zandt County Sheriff's Department. I've spoken, I believe, with Deputy McLeish about that. I don't recall if it was her or the lead investigator. They're investigating that for me as well.
Okay.
So we are aware, we're not opposed to Mr. Ashmore's request for discovery. We're attempting to comply. We're in the process.
Okay. All right, Mr. Ashmore, if you want to go ahead and address the allegations that Mr. Spriggs has filed in his written form dated, I believe it was, it's not dated, but it was received March 24th of 2022.
sure thing, Judge. Thank you for that opportunity. Mr. Spriggs has been given authority in the amount of $500 for an investigator. And I think the chief complaint that I take away from that is that that investigator is not being used to investigate this matter. Here's my concern. That is a generous amount, but I also know a very limited amount from the taxpayers of Van Zandt County, Texas, to investigate the defense of this crime. And I don't have anything to investigate just yet. I do not have a witness list. I do not have forensic examiners. There is nothing to send an investigator to do at this point. We've been through the paper discovery. We've talked about what appears to be a voluntary confession. We've talked about the crime scene photos. These are not things that require us to burn through the only investigatory fee we may get. There's a disagreement about how that's being utilized. I think it's premature to go through it at this point. This is a complicated case. It has multiple witnesses. There's a 40 TDC offer on the table, and proceeding diligently but cautiously is, in my view, as the counsel of record, and I understand I'm court appointed, but prudence dictates I don't waste that money because I'm probably not going to get any more. And until there are locations and materials of things to get and interview and investigate and touch, until we have access to these tangible things, it's not wise for the defense to waste that money when we have a great deal of the evidence we believe that the state is going to be presenting in their case in chief, none of which requires the skill set of an investigator.
Well, and just for the record, I want to note that the order I signed approved $1,000 for an investigator.
Then forgive me for that mistake. That's still not a lot. That's a lot of money. But I have used investigators almost my entire career. One of my best friends, Vince Zubris.
No, I understand. I'm just noting for the record. I'm not saying it's a lot or it's a little. I'm just saying for the record, you said 500. It was.
And I apologize for that. It's still something we have to be judicious with because my experience is you don't get that very often and you don't usually get it twice. So until there's more to investigate, till we have more availability for tangible items, then again, it's my judgment call to protect that asset, to protect that resource until such time as there is more to investigate than the state's open file policy, which they have provided to us.
Okay. Mr. Spriggs, do you want to be heard?
Yeah, I have a problem, like, he doesn't come and see me in between court visits or anything. This, discovery, I've had him since November 24th. And he's had the investigator money, and when he don't see me in between court visits, how could he be working my case? He didn't even have my indictment until the last court visit on, February 22nd. He just got my indictment. I mean, he's not working my case. He tell me just sit here and I mean, you know what I'm saying? Just sit here, but you're not doing nothing. As, you know what I'm saying? Because it's a speedy trial act. You know what I'm saying? All that stuff. He said just sit and stop whining. And that's not cool. You know what I'm saying? I don't need back time if I have to do time, but I got attacked in here and I got congestive heart failure. I've asked him, he's told me 3 times that he's gonna file for a PR bond, which he says, I don't want to go get shot down. Well, go and get shot down, better than not going at all.
I'd like the opportunity to respond to the bond request.
Well, let me ask you. So, Mr. Spriggs, how do you know that he's not working your case? Just because you don't see him, do you assume he's not holding your hand and talking to you every day? You assume that he's not working your case?
No, he doesn't. In between each court date, if I had one visit, you know what I'm saying? Because I've been studying the law too on the kiosk, and I got a law book. You know what I'm saying? I'm supposed to know everything that they got against me. You know what I'm saying? He hasn't told me anything. This right here, he just said he requested a discovery. He requested the discovery back in December 16th when I first came to court. He requested that, and he hasn't told me nothing about it. I don't even see him until court date, and then he come in here and he don't want to talk about it. He's like, yeah, well, we can't talk about it now. Let's talk to you later. And then he don't see me until he sets it up for 2 or 3 months later. You know, you understand what I'm saying, Honor?
Well, I understand what you're saying because you're telling me. I'm not dumb, Mr. Spriggs.
I'm sorry. I don't mean, I'm not trying to be flying or nothing. I mean, if he would, let me know what he's got, but he hasn't let me know what he's got at all. And he doesn't see me in between visits, you know, in between court dates, not in between visits, because, you know what I'm saying, if he was working my case, I feel like he's got too many on his caseload, because that's what he always tells me. I got court, big caseload here, I got caseload there. He doesn't have, supposed to have like 10% of his revenue come in on pro bono, right?
Well, why are we talking about pro bono?
Because if I would paid him.
Well, he's not doing your case pro bono right now.
I know he's not, but he acts like it. I mean, he might get $500, but he's not doing it like he's actually trying. And I don't feel that he's trying to work my case.
Do you want to hire your own attorney?
I don't have the money to.
All right, Mr. Ashmore, you want to respond?
Yeah, Judge, we have had multiple conversations about Mr. Spriggs and a bond reduction, because a PR bond for a first-degree felony homicide in the state of Texas is not in the realm of possibility in this universe. That being said, I have thoroughly reviewed the statute, and there's no statutory grounds that I can see that the bond, which is only $1 million, right, can be in good faith reduced to what, $750,000 or what have you. And the best argument there is because the victim's already in glory. Under the statute, right, the attorney's got to bring anything you put your name and you sign in good faith. That's a requirement of the state bar when you get your law license. And filing a motion that does not even meet the statutory requirements for bond reduction is not an efficient use, doesn't put Mr. Spriggs' case in a good light before the court. And I can't see any way to frame an argument under the statute that comports with the duty of candor and ethics to the court, period. I just can't see it. The bond research I've done with my appellate attorney
And that's okay, Mr. Ashmore. I'm not going to entertain a personal bond for Mr. Spriggs if you're court appointed or he's paid you $1 million. I'm not going to entertain a personal bond or a PR bond on this case. So I'm not worried about that. Will you address for me his allegations that you're not visiting him, that you're not discussing the case with him, and that he feels like he's in the dark? Will you address that for me?
Yeah, my response to that, Judge, is we have utilized multiple times the video conferencing system, and we get 20 minutes at a time, and we'll do multiple visits. Now, I will tell the court that in preparation for Mr. Tabby's trial, which we completed last week, I have not been able to catch my clients on a regular basis just due to my schedule and the schedule here at the Van Zandt County Justice Center. That being said, I've made efforts, and through whatever concerns through February, all related to whether or not he had competency to be indicted. And if he's got questions about the indictment and the reading of the indictment, they all turned on the issue of competency, which was resolved in the month of February. And so I'll tell the court that February, March, April, my recollection is that we've utilized the video conferencing. We've had an extended meeting here at the visitor's window, at least one, but my recollection is more than one, with my colleague. And I've been up here with my colleague, Mr. Craddock, and Mr. Questenberry, and I've also had access to computers and all the digital data. So I strongly refute, as strongly as I can, that I haven't worked the case and I haven't kept them informed. I am not available for a weekly visit with Mr. Spriggs, especially since we don't have any further discovery than the materials we've already gone over with him. I'm happy to make myself more available as we get more information, and I will do so. But I strongly refute the allegation that I have not been keeping him informed and not working his case.
All right. So what is your request, Mr. Spriggs?
I'd like to have a new attorney.
And you're not going to hire your own attorney?
I don't have a money to, but I don't feel that he's representing me, you know? Yeah, he does all these visits and everything you see. He says he did. It's on the record. It's on his court record. You know what I'm saying? You can see it. I've left him 20 messages in between, you know what I'm saying, in between the court dates to try and talk to him, because I'm trying to help him word my case too. But he says he's so backed up and packed up. You know what I'm saying? And
I'm going to put it on the record. I've asked you not to communicate on that system. It's not secure. It's not attorney-client privileged.
I'm just telling you what you're doing wrong.
I hear you, and I'm telling you that's not the way we need to communicate, period.
Mr. Ashmore, do you believe that you've reached a conflict of interest or an impasse? Do you believe that the attorney-client privileges deteriorated to such a degree that you can no longer represent or communicate with Mr. Spriggs? And he
Judge,
said,
I think Mr. Spriggs had exactly the same problem with Ms. Beasley. I know he's upset because he's got a broken hand and that injury occurred here. I know he's upset because he's looking at 14,000 days as an offer from the state of Texas. I know he's upset because his son got COVID and he wants to see him. I get all that. I don't believe that our relationship's deteriorated. I've asked him for grace and patience, and I've encouraged him to exercise it. That's my position, Judge.
all right, thank you, Mr. Ashmore. All right, Mr. Spriggs, at this time, I'm going to deny your request to remove Mr. Ashmore as court-appointed counsel. And if you feel like the issues persist, then you will inform the court and I will conduct another hearing and we'll talk about it again. Okay?
Thank you.
We're going to reset your hearing, Mr. Spriggs, so that Mr. Ashmore can make an announcement on pretrial on those issues he informed me earlier. We're going to reset till May 10th at 1:30.
Judge, also, if I might, I spoke with my investigator while this hearing was ongoing. We have received the full autopsy report, Mr. Ashmore. It's available at my office if you'll contact us to make arrangements to get it. We got it last week, so just recently.
Thank you.
And I will continue to investigate. The sheriff's office, Deputy McLeish, texted me that there are a number of items that the sheriff's office is in possession of, and I will get with her. We will coordinate allowing you access to all that as well.
Thank you.
All right, well, Mr. Spriggs is signing. I'm going to try to bring in Ted Michael Russell.
Yes. Up your way. I don't know. You're welcome to check those. Hit bottom left.
Not getting any response from the Henderson County. I believe that's Henderson County. So if Mr. Simmons, if you're ready, I'll get you in if you're ready. Mr. Rojas.
I'm sorry, Mr. Simmons.
Your Honor, Hillary, can you hear me?
Yes.
That second judgment you sent over is still not correct.
Okay.
Okay, what's the issue on the second? on the corrected one.
There's two places on page one that needs to be $3,000. You only change one, and on page two, there's to change the fine.
Under the terms of plea bargaining, before it's rewritten.
Yeah, where it says that the plea agreement, and then you have the fine amount at the bottom left, and then on page two, the bottom right.
Okay, all right. I will let Miss Abney know that we missed the one on the front and the one on page two, and then we corrected the second place on the front page, correct? So those are the only two places that need to be amended.
Yeah, there's like 351.
I will go have her change. She has the editable copy. I'll have her resend that to y'all as soon as we can.
Okay, let me get Mr. Rojas cleared from security up front, and we'll get this done.
Thanks, sir.
So are you only expecting one judgment?
Okay.
Mr. Ashmore, are you done? I'll tell you what, if you want to come on over this way, I'm not getting Henderson County to respond. So if you want to come on over to the courthouse, if he does appear, we can do it from over here. And you can go ahead and you do Mr. England.
Thanks, Judge. Mr. Simmons, you said to go get Mr. Rojas?
Yes.
Okay. Look, man.
Yeah, I appreciate it.
You got the correct paperwork?
Still
working on it.
It's still coming, I think.
Are you fixing to appear for this? Are you live?
Yes, Deputy, we're still live.
Gotcha.
Only 258.
Okay.
238, yes.
All right. Are you still waiting on your paperwork from Mr. England?
Yeah, we don't have the judgment yet. You're on 238, Your Honor. That's the only thing we have that we're missing.
Oh, I'm sorry, Mr. Rojas. Okay. Well, I'll tell you what, let's go ahead and we'll go through the plea, and then when they get the paperwork over there, then they'll fingerprint you on the correct one. We'll just go off of this other one.
Thank you, Your Honor.
All right, this is cause number CR 21238, State of Texas versus Xavier Armando Rojas. Mr. Rojas, if you'll raise your right hand. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth? So help you God.
Yes, Your Honor.
All right, you may put your hand down. Your name is Xavier Armando Rojas, is that correct?
Yes, sir.
And Mr. Rojas, are you a United States citizen?
Yes.
Do you read, write, and speak English?
Yes, sir.
And have you ever been diagnosed with any type of mental condition?
No, Your Honor.
In this case, you're represented by your attorney, Mr. Simmons and Ms. Barberi. Are you pleased with their representation of you?
Yes.
Do you feel like you've had enough time to discuss your case with them and have all of your legal questions answered?
Yes, sir.
Is there anything about the paperwork that you've read and signed today with Mr. Simmons that you do not understand?
No, sir. We went over it.
Mr. Simmons, do you believe that your client is competent today? Have you explained to him his legal rights?
He is competent, Your Honor, and I have explained everything on the paperwork with him, and he understands what he's giving up.
Thank you. All right, Mr. Rojas, you are charged by indictment with a third-degree felony offense of unlawful possession of firearm by a felon. That does carry a range of punishment of a minimum of 2 years to a maximum of 10 years and a fine not to exceed $10,000. I see that the plea agreement is that you would plead guilty to that charge. The state would be recommending that you be convicted and sentenced to 3 years in prison with a $3,000 fine, court costs plus fines and reimbursement fees. And the state would be dismissing an unfiled a filed possession of marijuana less than 2 ounces, and you would receive 2 days credit towards your sentence in this cause. Is that your understanding of the plea agreement?
Yes, Your Honor.
All right, understanding the plea agreement and the range of punishment, you still wish to go forward with your plea?
Yes, Your Honor.
Mr. Rojas, how do you plead to unlawful possession of firearm by a felon?
Plead guilty.
Mr. Rojas, do you plead guilty because you are guilty of committing that crime?
Yes, sir.
Has anyone threatened, forced, or pressured you to plead guilty today?
No, Your Honor.
All right, court accepts the defendant's plea of guilt. Any objection to the state's evidence as offered?
No, Your Honor.
State's evidence is admitted and the court takes judicial notice of the defendant's judicial confession. Anything further from the state?
Your Honor, the gun that was seized in connection with this case is Mr. Rojas's wife's firearm. I am happy to send a disposition to DPS who currently has that, that can be provided back to her, given proper documentation, clearance of a background check, et cetera.
Okay. Yeah, I would direct you to do that. DPS will need that documentation before they'll release that firearm.
Yes, Your Honor.
Anything further from the defense?
Not on that case, Your Honor.
All right, then court is going to review the evidence. All right, court has reviewed the evidence. Court finds that there is sufficient evidence to convict the defendant of this offense. Court will follow the plea agreement. The court convicts Mr. Rojas of unlawful possession of firearm by felon, assesses his punishment at 3 years confinement in the Texas Department of Criminal Justice Institutional Division, orders him to pay a $3,000 fine, $290 court costs, and $85 in reimbursement fees. Court dismisses DA 2021-201, possession of marijuana less than 2 ounces. The court awards Mr. Rojas 2 days credit towards his sentence for the time that he has spent in jail on this cause. Mr. Rojas, you are remanded to the custody of the Van Zandt County Sheriff so we can carry out the terms and conditions of the sentence. Once they get the new judgment, then the deputies will have you fingerprinted over there. Good luck to you.
Your Honor, there is a misdemeanor case too, 256. I don't know if you have that one in front of you.
Yep, there it is. My bad. All right, Mr. Rojas. I would have done this at the same time. My bad. Mr. Rojas, you've also been indicted with, you've been charged by information with driving while intoxicated in CR 21256, Class B misdemeanor, carries a range of punishment of up to a maximum 180 days and a $2,000 fine. Plea agreement is that you plead guilty to that charge. Punishment recommendation is 2 days in the county jail with you receiving credit for 2 days of time served with a $100 fine, court cost of $270. How do you plead to that charge?
Plead guilty, Your Honor.
All right, court accepts the defendant's plea of guilt. Any objection to the offered evidence in that case, Mr. Simmons?
No objection, Your Honor.
All right, court accepts the defendant's plea of guilt and admits State's Exhibit 1. Anything further from the state?
No, Your Honor.
Anything further from the defense?
No, Your Honor.
All right, court finds that there's sufficient evidence to convict Mr. Rojas. Court will follow the plea agreement in this case. The court convicts Mr. Rojas of driving while intoxicated, Class B misdemeanor, assesses his punishment at 2 days confinement in the county jail, issues him credit for time served, orders him to pay a $100 fine, $270 court cost, and $35 reimbursement fees. Mr. Rojas will be remitted to the custody of the sheriff so we can carry out the terms and conditions of the orders in each one of these causes.
Thank you, Your Honor.
Thank you, Mr. Jones. All right, Mr. Russell, I know that you can probably hear me. I think you're muted. I won't be able to hear you, but Mr. Ashmore is on his way over. Oh, there he is. He just walked in. He had to come over from the jail. I have Mr. Russell on Zoom at this time. Can you have that unmuted, Mr. Russell? Right, just over Mr. Russell there, right. Thank you. There you go.
All right, can y'all hear me?
Yes, we can. Thank you, sir. All right. Sorry. It's okay. Sorry for the delay. Appreciate your patience. All right. Let me flip over to this case here. All right. Mr. Russell's case was called this morning on the morning docket CR 21-339-340. And Mr. Russell is set for docket call in each one of his cases. Any announcements, Mr. Ashmore?
Judge, I have a new offer from the state of Texas, which I have not been able to talk to you about, although I talked to your mother today, sir. The situation, as I understand it from the state, is that there are now additional charges in Henderson County. Van Zandt County will agree to 30 on the aggravated assault, 1245, your remaining business here in this county, as well as, if can be done, 1245 or run concurrent, anything pending in Henderson County. I believe, if I understand correctly, that Ms. Heisel has already reached out to Mr. Danny Cox in the Henderson County District Attorney's Office. Mr. Russell, I haven't had a chance to confer with you about that yet because you're there and I've been here all day, but I want to let you know that's the current officer. 30, disposing of all your business pending approval from Henderson County. That being said, we really don't have any pending pretrial motions or any other announcements to make.
All right, what I'm going to do is, in light of the offer being extended to Mr. Russell today, I'm going to reset it, give you time to speak with him.
Thank you, Judge.
About the state's offer. So I'll reset Mr. Russell until May 10th.
What about the, I was wondering about the reinstatement of my bonds. I was charged with failure to appear, but I spoke with my bondsman and I was charged with failure to appear while I was here in Henderson County awaiting to make bond on these charges, and I would like to have a chance to get out to afford a paid lawyer if at all possible.
That motion will have to be made by Mr. Ashmore, and then we'll have to schedule it. The state has to get notice, and then we'll set it for a hearing.
Okay, because if, like I said, I was down, I went to go clear my head at the beach for a week or whatever, but the mowing season's coming back up. And I was pulled over, and the reason why I got reincarcerated is because of failure to appear. And like I said, the only reason why I didn't appear is because I was incarcerated.
I understand. I'll let you get with Mr. Ashmore on that, and he can file that motion. We'll set it for hearing. State has to be given notice of it, okay?
Okay.
So as soon as that's done, we can set it, as soon as it's filed, we can get it set as soon as possible for you.
Judge,
Okay, thank you.
may I clarify the record?
Yes, ma'am. Please.
His failure to appears are out of Henderson County. To my understanding, he does not have a current failure to appear here. The state did file a motion to hold his bond insufficient based on the new charges in Henderson County, but my understanding is that the failure to appear holds are Henderson counties, not Van Zandt counties.
I'll let the state defense discuss that. So I've reset it to May 10th, and I'll let y'all bring any information to me later that y'all deem relevant. All right, thank you, Mr. Russell, and tell the jail staff there I appreciate their help. Sorry for the delay in getting to your case.
Yes, sir. Thank you, Judge.
You're welcome. All right, Mr. England. All right, this is cause number CR 21-356 and CR 21-377. State of Texas versus Matthew Virgil England. Mr. England, if you'll raise your right hand. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right, you may put your hand down. Your name is Matthew Virgil England, is that right?
Yes, sir.
And Mr. England, are you a United States citizen?
Yes, sir.
Do you read, write, and speak English?
Yes.
Have you ever been diagnosed with any type of mental condition?
No, sir.
In this case, you're represented by your attorney, Mr. Casey Ashmore. Are you pleased with his representation of you?
Yes, sir.
You feel like you've had enough time to discuss both of your cases with him and have
Yes.
all of your legal questions answered?
Yes, sir.
Do you think about this paperwork that you've read and signed today with Mr. Ashmore that you do not understand?
No, sir.
Mr. Ashmore, do you believe Mr. England to be competent today?
I do, sir.
Have you explained to him his legal rights and also the advantages and disadvantages of a deferred adjudication plea?
Yes, Judge, we've discussed that there's a huge advantage multiple times. Huge advantage with this because he will, upon successful completion of the period of deferred probation, get all his rights as a citizen back. The disadvantage is that there's a paddle out there with his name on it, and if he trips up, it opens him. That paddle is the full range of punishment. So he understands the danger of getting whacked by that paddle. We've discussed it multiple times, and he's aware of that, wants to take the opportunity to get his life back, get all his rights as a citizen of the United States of America back.
All right, Mr. England, I see that you have two charges in this court. You have one that is a third-degree felony assault of a public servant that carries a range of punishment from the minimum 2 years to the maximum 10 years and a $10,000 fine. You also have a Class A misdemeanor, driving while intoxicated, second offense, which has a range of punishment up to a maximum of 1 year confinement in the county jail and a fine of not more than $4,000. I see the plea agreements are on the assault of a public servant. The state is offering you deferred adjudication, 4 years community supervision, $2,500 fine, weapon forfeiture, and they would be dismissing an unlawful carrying of a weapon and interference with public duties, in addition to your court costs and reimbursement fees. In your DWI second, the offer is 119 days confinement in the county jail, with you receiving credit for all 119 days plus a $100 EMS trauma fine. Is that your understanding of the plea agreement in each case?
Yes, sir.
Understanding the range of punishment, understanding the advantages and disadvantages of a deferred adjudication plea, do you still wish to go forward with this plea agreement?
Yes.
All right, Mr. England, how do you plead to assault of a public servant?
Guilty.
How do you plead to driving while intoxicated, second offense?
Guilty.
Are you pleading guilty to each one of those offenses because it's true that you committed each one of those crimes?
Yes.
Has anyone threatened, forced, or pressured you to plead guilty to either crime today?
No, sir.
All right, the court will accept the defendant's plea of guilt. Mr. Ashmore, any objection to the state's evidence is offered?
No, Your Honor.
All right, state's evidence is admitted, and the court takes judicial notice of the defendant's judicial confession. Anything further from the state?
No, Your Honor, we would rest and close at this time.
Mr. Woodwike, any victim impact or victim compliance with the assault on the public servant?
Judge, I don't believe that we have spoken with Sergeant Hunter at the jail. I'm unaware if we have any I don't recall that is one that requires notification. I don't think that she has been notified. I don't know if she has a interest in this. She was headbutted in the face. Unfortunately, that is an all too common occurrence for jailers. I can speak with her if you'd like me to, but I don't believe that the state has required notification on this charge.
I was just checking. Anything further from the defense?
No, Your Honor.
All right, court's going to review the evidence. All right, the court has reviewed the evidence. Court finds sufficient evidence to convict Mr. England in each offense. Court will follow the plea agreement as it's recommended by the state of Texas. Court hereby defers a finding of guilt on the charge of assault public servant, third-degree felony. Court assesses punishment at 4 years community supervision. Orders fine of $2,500, court costs of $290. Orders Mr. England pay reimbursement fees of $1,010, and the court dismisses under section 1245 unlawful carrying of a weapon and interference with public duties, and orders the forfeiture of the weapon seized in connection with this offense. With regards to the DWI, the court convicts Mr. England of driving while intoxicated, a second offense. Court assesses his punishment at 119 days confinement in the Fayette County Jail, with him receiving credit for 119 days served previously. The court orders him to pay a $100 fine, court costs of $270, reimbursement fees of $15. Mr. England, can you tell me what happens if you go on probation and you violate any of the conditions of your community supervision?
Yes, sir. I go to prison.
For how long?
2 to 10.
2 to 10. That's right. So I want you to be thinking about that. And if you get on probation and you drink a beer, one beer, I'm not going to punish you for drinking a beer. That's going to be your violation that brings you back before the court. When I punish you, I'm going to go back and I'm going to read about you drinking and driving and getting pulled over and being incoherent and refusing tests and trying to walk out in traffic, and then going to the jail and headbutting a employee who's trying to do her job. That's what I'm going to do. That's what I'm going to punish you for. Okay, it's not going to be that 1 year. I mean, that's not going to be that one violation. You understand? That one beer.
Yes, sir.
Understand?
Yes, sir.
All right, Mr. England, you hereby remanded to the custody of the Van Zandt County Community Supervision and Corrections Department so they can carry out the terms and conditions of your sentence and have you come forward to be fingerprinted by the deputy. After that, report over here to Ms. Burns and she'll give you more information. State, I need you all to sign the plea papers too, and then that victim notification will be over here with Patty.
Yes, Judge, I'll be over in just a few minutes.
Thank you, sir. I believe that completes everything on the docket today.
I believe so as well.
All right, thank you all. See you next time.
Thank you, Your Honor.